The next case to come before the court is Christopher Slattery et al. v. Seemray LLC et al. Each party will have up to 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. And if you do plan to reserve time, please let me know as I'll be keeping track of the time. And the arguments are being recorded, so please stay behind the podium and keep your voices up. Please don't use, should it be relevant, the names of children, minors, or victims during your argument. You can use you can refer to people by initials or terms that are general in nature. The judges have read your briefs and are ready to proceed when you are. Would the appellant like to reserve time for rebuttal?
Yes, Your Honor, perhaps 2 minutes.
Very well. And you may start when you're ready.
Good morning, and may it please the court. My name is David Sporar, and I represent Christopher Slattery and Megan Slattery, who are the appellants in case number 30346 and the appellees in case number 30459, which have been consolidated. The Slattery's appeal concerns summary judgment and the granting of summary judgment against them by the trial court. And the defendant's appeal concerns the denial of the motion for sanctions. I would like to address the motion for sanctions issue first because it involves broader issues that maybe put our appeal into context. So, first, some very brief background for the record. The Slatterys sought to purchase windows for their home in 2019 from the defendants. And the record reflects that they intended those windows to have a certain energy efficiency rating called a solar heat gain coefficient rating that insulates against sunlight that generates heat in their home. They also intended to have the project be turnkey, which is commonly understood as both providing the windows or the product itself and also the installation by the same company. And they learned about the defendants and visited their showroom, and Mr. Slattery testified that he had these conversations with the defendants, specifically the two companies' common owner, Rostislav Arnaud, on multiple occasions, including at the showroom, at which time he took a photograph of one of the display windows that had this rating. The parties engaged in correspondence over the next several months. Quotes were exchanged, and the final quote was for approximately $24,000 for the windows. It did not include installation. The Slatterys paid the money and received the windows, and they entered into a separate oral agreement with Mr. Arnaud for the installation. The installation had problems, and at that time the Slatterys learned that the windows did not have the solar heat gain coefficient rating they desired. They expressed those issues to the defendants. There was evidence of an email from Bogdan Glushko, an agent and associate of Mr. Arnaud and the companies, where he recognized that perhaps the windows should have had that rating, and he offered to replace the windows. Now, the parties weren't able to resolve their differences, and this lawsuit ensued. The Slattery sued the defendants for breach of contract, fraud, and they included Mr. Arnaud as an individual defendant. The parties engaged in discovery, and then they filed cross motions for summary judgment. The Slattery's motion for summary judgment was denied, and the defendant's motion for summary judgment was granted. The defendants then filed a motion for sanctions, which the trial court denied. So, the motion for sanctions basically claimed that the lawsuit was frivolous under Ohio Revised Code 2323.51 because it either was intended merely to harass the defendants or it had no basis in law. And they also claimed that it violated Rule 11, that there were not good grounds to file the lawsuit. And the judge disagreed. She concluded that there was some evidence in the record to support those claims. That wasn't a determination on the merits, but the fact that the Slatterys did not prevail on summary judgment doesn't render the lawsuit and their claims frivolous. The fact that some of the evidence that the court relied on to conclude that the claims weren't frivolous was stricken from the Slattery's motion for summary judgment doesn't mean the claims are frivolous. The fact that the defendants disagreed with what the record demonstrated does not render the claims frivolous. At the end of the day, the court found that there wasn't evidence that the complaint was intended merely to harass the defendants. There was a legitimate dispute, and there were facts that demonstrated that there was an agreement to purchase windows with the rating and to have a turnkey project with the installation, and those supported the breach of contract claims. Now, to the extent the Slatteries interpret the evidence to demonstrate that there were misrepresentations regarding those matters, that supports the fraud claim. And there was evidence of damages, specifically with respect to the cost of the windows reflected in quotes. So the court drafted a 13-page, well-reasoned opinion outlining these matters. And really, the defendants only insist that there's not evidence supporting these things, but it was in the record, and that is enough. And again, there's a difference between that evidence being stricken for purposes of summary judgment, which is a procedural matter, and the fact that this material was in the record and showed that these claims were based in fact. Now, with respect to, and so because the judge's decision was supported by the record, it was supported in law. And I want to emphasize that it is not uncommon for plaintiffs to assert fraud claims in addition to breach of contract claims. Perhaps the plaintiffs can't prevail on both at the same time, depending on how the facts shake out. But it's not frivolous in the first instance to do so. And it's not frivolous to assert a claim against an individual business owner in his individual capacity, especially under facts such as these, where they were small, closely held companies where he was the individual owner of both companies. So, again, the fact that the plaintiffs weren't able, that the Slatteries weren't able to prevail on summary judgment doesn't mean that their claims were frivolous. It means that they didn't prevail on summary judgment. And because the trial court's decision is ultimately subject to substantial deference, considering that the trial court is in the best position to review the material presented in the first instance, the trial court's decision denying the motion for sanctions should be affirmed. Now, with respect to summary judgment, the Slatteries take issue with only one part of their case, and that is the denial, or the granting of summary judgment on their breach of contract claim related to the solar heat gain coefficient. The court found that there were two issues. One, she concluded that the Slatteries hadn't pointed to evidence of the existence of any agreement for those for the windows to have that rating. And two, the court found that even if there was evidence, it would be barred by the parole evidence rule. And the Slatteries submit that both of those findings are incorrect. The Slatteries pointed to Mr. Slattery's own deposition testimony, which reflected he had numerous conversations with Mr. Arnott about this rating. They also pointed to the photograph that Mr. Slattery took of a display window that had that rating, which corroborates his testimony that he was talking about that with Mr. Arnott at that time. And there's the email from Mr. Blushko after Mr. Slattery complained that demonstrates Mr. Blushko conceding that perhaps the windows should have had the rating and that he would be willing to replace them.
But this was all before there was a written contract, a quote, and an acceptance of a quote, correct?
The communications with Mr. Arnott and Mr. Slattery were before the quotes. The photograph was before the quotes. The email was after the quotes. So the point is there wasn't a written contract for these windows. There were quotes for the windows, which were accepted. But those quotes alone aren't a fully integrated written agreement.
But by law they are, right? Quote, you accept a quote and there's contract language within that quote. Doesn't that make it a written contract?
No, It means that there are writings that evidence the existence of a contract. But the court can, if it's not a fully integrated contract, if there's other terms that would be intended to supplement it, not contradict or vary, then those aren't barred by the parole evidence. The defendants point to a clause in the quotes to suggest that there's an integration clause. And that language is not an integration clause. It effectively says by paying this quote, you are accepting this quote. But it doesn't say this quote is the full embodiment of our agreement about the windows. And one fact that's undisputed that supports the conclusion there are other agreements related to that is the oral agreement for the installation. And when a writing is silent, even what appears to be a written contract is silent on a term, and you intend to introduce other evidence of terms not inconsistent with or contradictory to it, you can consider that evidence to determine whether the contract should be supplemented with those additional terms.
Counsel, I do want to let you know you're moving into your rebuttal time.
Well, thank you. So the point, for these reasons, they did point to evidence in the record that supported the existence of an agreement for this rating to be under windows, and the parole evidence rule did not bar consideration of that evidence. Those two issues being erred by the trial court, the Slattery's request that the trial court be reversed in that respect. Thank you.
Thank you. When you come up for rebuttal, you'll have a little over 4 minutes.
Good afternoon, Your Honors. May it please the court, counsel, my name is Brian Carr, and I represent the Applebee's Seemray LLC, Argo Inc., and Rostislav Arno. We are the Applebee's in the frivolous conduct component of this case. I understand I'm not going to get rebuttal time necessarily, so all of my arguments will be directed at both the summary judgment appeal and the frivolous conduct appeal. In essence, I'm asking this court for two rulings. Obviously, I'm asking this court to affirm the trial court's grant of summary judgment to my clients. But also, I'm asking this court to reverse the trial court's denial of my motion for attorney fees and sanctions for frivolous conduct. I think while the trial court correctly found for my clients in granting summary judgment to them, I think the trial court erroneously found that frivolous conduct did not exist. I take it by counsel's brief and comments that the appellants are waiving or abandoning their claims on the fraud and personal liability components of their complaint. I put that in my brief, but again, I wanted to articulate that here. So what do we have here? We've got a complaint that was filed against my clients for fraud, breach of contract, and some corporate veil piercing / personal liability arguments. I want to focus on two arguments that the appellants have raised, both at the trial court level and before this court, because I think when this court looks at the two claims that the appellants made, it will see that there was never any evidence to support them, which supports my motion for frivolous conduct that the trial court denied. First, the Slattery's instituted litigation for the breach of contract because of the solar heat gain coefficient, SHGC. In essence, the Slattery's are telling this court, and told the trial court, well, the Applebee's breached the contract because there was no appropriate solar heat gain coefficient. Well, the problem is, now I feel I'm well versed in the facts of this case because I've been living it so long. Indeed, Judge Lanziger, you're correct. We had about 4 or 5 months where the parties negotiated a quote, a proposal, a contract, whatever you want to call it, doesn't matter what word you use. They negotiated every component of these windows for about 3 months. In the summertime, by the way, since we're talking about solar heat gain coefficient. And all the back and forth and all the emails and all the text messages that went back and forth between the Slattery's and my client, there was never any mention of a solar heat gain coefficient requirement. Setting aside the fact that we're in Northeast Ohio, and I don't think there's ever an issue about solar heat gain coefficient on a residential home, there was never any mention any communication whatsoever about a specific rating. The Slatterys had about 3 opportunities to carve up or revise the quote or estimate, which they did. But none of the revisions ever had to do with solar heat gain coefficient. None. It says very clearly on the bottom of all these quotes, once you pay the deposit, you agree that this page, this quote, is everything, every component about the windows. This is it. Also, on these quotes, it says in bold language, I believe, installation is not included.
Council, if we could talk for a moment about the coefficient, energy coefficient.
Sure.
The trial court's order says, although plaintiffs argue they promise to deliver the windows with the identical ratings as those reflected in the photo, this court is not persuaded. So we're on summary judgment, and the language, this court is not persuaded, could just be an inartful way of saying that there's no evidence, but it sounds like it's a weight of the evidence determination when the court says that. Can you speak to that?
Are you referring to the granting of summary judgment?
Yes.
Thank you, Your Honor. Indeed, what the trial court, I think, did, the trial court had before it this photograph. And the photograph that was taken by Mr. Slattery was of some window that he alleges was in the showroom of my client's warehouse. Okay, that's first. But I think the problem the trial court had and why it granted summary judgment, and again, I've been doing this a while, and I've rarely seen a 14 or 15 page order granting summary judgment. So the trial court really went through the task of analyzing everything when it granted summary judgment. But I think the trial court gave the benefit of every doubt to the Slatterys when looking at the solar heat gain coefficient argument.
Which would have been proper under summary judgment,
Of
right?
course.
All evidence construed and, right?
Absolutely, but once you get past this photograph that's just kind of floating in the ether, we look at the documents. We look at the follow-up communication or messaging or interaction between the parties to fully develop that one photograph. And I think the trial court took a look at all of the communications and all the emails and all of the quotes and said, well, okay, maybe in their mind they intended or wanted some specific solar heat gain coefficient, but nothing makes sense. Self-serving testimony, whether by affidavit or deposition, that doesn't save the day under Rule 56, as this court knows. So Mr. Slattery could have said, I sat down at Panera with Mr. App.No and we had a big discussion about the solar heat gain coefficient, but unless there's something to back it up that's not self-serving, it's just too bad under Civil Rule 56. So I think the court looked at the photograph and kind of looked at everything else that was before her and said, okay, well, you have this photo, I understand what you're saying, but I'm not persuaded. I've taken this photograph. I've given you the benefit of the doubt. I'm looking at all the emails that you sent the appellees from May of 2019, Your Honor, to January of 2020. There is not one mention of solar heat gain coefficient. The appellants want to continue to refer to this email that was stricken by the trial court from the salesperson at Seemray. This email, I think it's Exhibit I in my motion for summary judgment. This email doesn't say anything about solar heat gain coefficient, and oh yeah, maybe we gave you the wrong window. It says, as any salesman would say to a customer, I apologize for the misunderstanding. Maybe we'll try to help you out. That's all it says. And this goes back to my motion for sanctions under the frivolous conduct statute, both under 2351 and Civil Rule 11. One point that sticks in my craw to this day, Your Honors, is the fraud claim. The Slatterys sue my client for fraud, and I don't make a habit of suing people for fraud, so it's not that typical to sue people for fraud just on a whim. The Slatterys filed this complaint suing my client for fraud based upon a bait and switch kind of theory that they said it was going to be a turnkey project where this company was going to do everything, but then they got this other company to do installation. That's paragraph 26 of the complaint. I have it memorized almost, word for word. However, 5 pages later, in the complaint that's about this thick because it contains all these exhibits, is an email between the Slatterys and Argo and Seemray and my client, where it's articulated, hey, let's schedule and get a contract together for installation through Argo Inc.
That could still be bait and switch though, right?
I'm sorry?
That could still be bait and switch if you already agreed to buy the windows, but now you're having to deal with an installation company that you didn't.
I may tend to agree with you, Your Honor, if the quote didn't say installation is not included. That's the only problem I have. So on the one hand, they're suing my clients for fraud, saying they said installation was included, and 5 pages later in their complaint, they attach an email that they were a party to where it says, oh, installation is not included. It's those factors that raised the specter of Civil Rule 11, the motion. The breach of contract, going back to the frivolous conduct and why I think summary judgment was correct, but the denial of frivolous conduct was not. When you have a breach of contract claim against someone, we all know the elements. You have to have damages. The Slatterys came to the trial court with not a scintilla of damages. These windows have been in this house since October of 2019. From October of 2019 to the date summary judgment was granted, we didn't get one repair bill. We didn't get one repair bill from any glass company where they had to caulk anything. I mean, there was nothing. There was absolutely nothing. And so it's this basis, these issues that form the basis of the frivolous conduct motion. My client, and this is part of the record, this is in the record, the deposition testimony, Your Honors. My client was forced to defend a breach of contract, a fraud claim, and a convoluted piercing the corporate veil claim. Okay? He had to spend money. Whether it was going to be me or any other lawyer, he had to spend money. On the flip side, the appellants had their brother, who was just out of law school a year or two, handling the case on a 1/8 contingency basis. Never heard that before, but that goes to show you that this was kind of a quasi, I hate to use the word shakedown, but compelling my client to spend money defending these serious claims when, on the flip side, you don't have to have that same financial expense. That's just not fair. In the state of Ohio or anywhere else. I know I'm kind of going in a bunch of different directions here, Your Honor. The parole evidence rule. The trial court had it spot on, and I think there's a case or two that I put in my appellate brief that says when you have a contract that has all the terms in it, you cannot modify it, change it, or add anything. Or add anything. And that's what we have here. Okay, we've got a contract that has all the terms and conditions and parameters and sizes and shapes of these windows. For the Slattery to try to squeeze in, after the fact, a solar heat gain coefficient changes and adds a term to the contract. For the Slatterys to rely upon, in their appeal, this email from Bogdan, the salesperson, when it was struck by the trial court, it represents that it says something it doesn't, is just the way that the appellee in my client had to deal with the litigation for close to 2 years. I would just turn to, and I understand that no court, whether it be a municipal court, county police court, probate court, what have you, no court wants to punish a litigant under the frivolous conduct statute. I get it, I've been doing this a long time. But I think really all you need to do is look at the trial court's May 11, 2022 order, when she grants summary judgment for my clients. If you look at some of these findings in a vacuum, they could easily have been in an order finding frivolous conduct. And this is this is where I'll close. I don't know how much time I have left. This is in my merit brief. Thank you, Your Honor. My merit brief, pages 9 and 10. These are just 4 of the findings of the trial court. and I'm quoting here, this is, plaintiffs failed to point to any evidence to support their assertion that Seemray agreed to provide glass meeting any SHGC rating. In fact, there is evidence to the contrary, as no SHGC rating is mentioned in the written contracts, nor communications between the parties prior to installation. And Judge Hensel, I think that goes to the first question you had about where the trial court saw the photograph and did a little bit more analysis. The second point that the trial court articulates, all quotes clearly and unambiguously stated installation was not included. Next, plaintiffs were aware prior to accepting the June 7, 2019 quote that installation would be provided by a third party. And lastly, plaintiffs failed to establish any damages. Your Honors, again, I understand why courts in general do not like to fine parties or counsel in violation of frivolous conduct statutes under the Civil Rules Revised Code. I understand that. But on the flip side, I think courts are obligated to protect litigants so that they are not dragged into the four walls of courthouses simply in attempts to get compliance or get action because parties have to make decisions on whether or not they're going to spend money with lawyers. I think that is what we want to avoid. So with that, I would ask this court to affirm the trial court's decision granting summary judgment, and on the flip side, reverse the trial court's decision to deny the appellants, my client's, motion for fees and sanctions under the frivolous conduct statutes. And again, I thank you for the time to be before you today.
Thank you, counsel.
May it please the court. The first thing I wanted to address in rebuttal is I wanted to point out that the lawsuit was filed by a duly licensed attorney by the state of Ohio, and the court found that the claims had some support, even if they didn't prevail on summary judgment. So ad hominem attacks on prior counsel are inappropriate. The biggest problem here, I think, is the defendants keep saying there's no evidence, but there's evidence. Christopher Slattery's deposition testimony is evidence. That photograph that he took and authenticated with his testimony is evidence. When he says that there's not a scintilla of evidence of damages, that's not true. The quotes have a price amount for the windows, and damages don't have to be proven with perfect specificity, but only reasonable certainty. The value of the windows is in the record, so there's evidence of damages. So, on summary judgment, I think the court simply overlooked the evidence of Mr. Slattery's testimony and the photograph and the email from Mr. Glushko that operates as an admission, as an agent of the defendants, that viewed in a light most favorable to the non-moving parties, the Slattery's on a defendant's motion for summary judgment, supports the conclusion that he was conceding the windows should have had that rating and that he would have replaced them. That's just a procedural matter. That's just for summary judgment. And although that evidence was stricken in the context of the Slattery's motion for summary judgment, because it wasn't sufficiently authenticated with an affidavit, it was presented by the defendants as Exhibit I to their motion for summary judgment. It was part of the record on their motion for summary judgment. And that record demonstrated a genuine dispute regarding whether there was an agreement to provide windows with that solar heat gain coefficient rating. And with respect to the motion for sanctions, the defendants seem to just be disagreeing with what the evidence shows. And they're angry that they had to defend themselves against the lawsuit. But those don't make a lawsuit frivolous. At the end of the day, there was evidence in the record that supported these claims, whether or not they would prevail on summary judgment or at trial. And again, the trial court's determination of sanctions is basically subject to substantial deference. For all of these reasons, the trial court's decision on the denial of their sanctions motion should be affirmed. But because there was evidence that viewed in a light most favorable to the Slattery's on the breach of contract claim related to the solar heat gain coefficient, that portion of the judge's decision, the trial court's decision, should be reversed. And
thank you both for your presentations.